Welcome to Litigation and Capital.
Hey there, you're listening to Litigation and Capital with Steven Mirsky, partner at Mirsky Corporate Advisors. Each episode, we break down high-stakes legal issues affecting companies like yours, those earning $10 to $100 million a year, so you can turn complexity into leverage and protect what you've built. Steven, welcome back.
Thank you for having me. Nice to be here.
All right, so we're talking about priority of interest, senior and junior creditors. Can you share examples from your practice where the distinction between senior and junior creditors directly impacted the outcome of a dispute or even a restructuring?
Sure. It's really important whether you're a creditor or you're a debtor trying to arrange a deal, the priority of interest between your creditors. Most lenders, such as a bank or SBA lender, they're going to want to have a first position security interest in your assets, right? What does that mean? That means that if you default on the loan, they're first in time, first in line to get the assets to cover the deficiencies in your default, right? Okay. So if you have someone that's first in line and you're coming in behind them, your rights are junior, meaning that your ability to collect on a default could be limited by the senior lender's interest in that collateral. And so if you're seeking to obtain a loan, right, a junior creditor is going to have to assess the risk of their ability to collect. It's a riskier transaction, right? Because they may be stopped by the senior lender. And there's a variety of things that we can do to sort of set forth the rights between the parties in the event that a dispute occurs. But as a junior creditor, you don't have the leverage in the negotiation, right? So
you're low on the pecking order.
You're lower in the pecking order, and the senior creditor can put in various limits that really limit your ability to collect until they're paid out in full. And this has practical implications in real estate transactions, in equipment finance transactions, and a variety of other ways that you're seeking to finance your business.
Can you explain what UCC1 filings are and how you've used those to secure creditor rights in multi-party disputes?
Sure. So a UCC1 filing is extremely important if you're a creditor. What it does is it puts you first in line, first in time, or it just gives everyone on notice, depending on where you are in line, of your rights to that collateral for that debtor. If the debtor files bankruptcy, right, this will help prove that you are a secured creditor and that you've perfected your security interests in the collateral. It's important to note that just filing a UCC1 doesn't inherently mean that you've perfected your security interest in the collateral, because perfection, which means that you really claim rights to the collateral, depends on what type of collateral you have a security interest in. And there's a variety of different categories of collateral that are kind of outside the scope of this discussion, but suffice it to say, you can have a collateral interest in accounts, in proceeds, in chattel paper, in documents, in investment properties, in deposit accounts, general intangibles. There's a wide variety of things that a secured party can have a security interest in, and a UCC1 is a good way of saying, hey, look, I've got rights to this stuff. In some cases, perfection is done by filing. In other cases, you need to have possession and control. And so in bankruptcy, it'll allow everyone to get organized and allow the bankruptcy trustee to manage the estate efficiently.
Do you have any examples or situations where the priority established by a UCC1 was challenged and resolved?
Oh yeah. So
you're like, how many do I do?
Oh yeah. So that's where it gets fun, right? there's context inside of bankruptcy court and outside of bankruptcy court where you can do this. Inside of bankruptcy court, you can file what's called an objection to a proof of claim, which essentially sets forth objections based on evidence that a security interest isn't valid. The other thing you can do is file an adversary proceeding seeking to determine the validity or priority of a security interest, which means that you have to file a lawsuit within the bankruptcy court for the court to say, yeah, this is valid or invalid. And there can be a lot of hand-wringing and fighting over these issues because the secured creditor is going to want to get paid, and the party that's typically bringing in bankruptcy court the complaint would be the debtor, who's trying to not pay the debt, to put it bluntly. Outside of bankruptcy court, it could come up in a dispute where there's litigation and a third party comes in and says, hey, look, you're interfering with my collateral. You're not first in time, you're not ahead of me. And here's why you're not ahead of me. And then the parties can battle that out. And that typically comes in where you have a friendly lender or friendly creditor who is trying to help a debtor out in a dispute because that creditor doesn't want it to have its credit risk heightened through the ongoing litigation.
And what enforcement strategies do you find are most effective for senior creditors with high stakes defaults?
You have to go through an escalation process. That's what I would recommend doing. Now you can come out of the gate and just try to foreclose on everything and really strong arm them, but that's going to ratchet up tension and potentially make things more expensive.
Yeah.
So what I would first try to do is come to some sort of a workout strategy, determine whether or not we can, have a forbearance period to see if we can let things go for a couple of weeks and then pick things back up, or months, whatever the period is. If that doesn't work, then, we do a notice of default. We make sure that everyone's on notice that we have rights that we can exercise under the contract. If your debtor is a particularly large party, or has tier one banks that are financing their working capital on a day-to-day basis, a notice of default could violate their main credit line, which is a big deal. And so they would not want those issues being raised. So people are, if it's a well-run company, they are concerned about notices of default. The next thing you could do is you could authorize or give notice of a private sale or a public auction. And that's where things get really tricky and really hairy. And then the other things you can do is just file a lawsuit and just try to foreclose on the security interest that way. So the law permits an escalation process. And as a practical matter, I would recommend that a creditor escalate because we have business relationships that we are potentially dissolving along the way, and you want to keep emotions down so you can get your collateral as cheaply as possible.
So on the other side, what innovative tactics have you employed to help junior creditors gain leverage or negotiate favorable outcomes in disputes with senior creditors?
This is where it can be fun if you're on the debtor side of the fence.
I like what you consider fun, by the way. What you consider fun is different than what other people consider fun, I think.
So having represented lenders my entire career, one thing I'm very sensitive to is the time value of money, right? $1 today is worth more than $1 tomorrow. And, the reason why there's interest rates in a transaction is because you're trying to compensate for the risk of the value of the dollar being less tomorrow. And so if you're a debtor who, where there's other creditors seeking to get advantage, the thing that you can do is extend the time of a response and gunk up the works. And if you're a junior creditor seeking to get advantage, what you can do is you can try to gin up the works by attacking the senior creditor as well, or teaming up with the debtor to attack the senior creditor. And there's a lot of different tactics that you can employ once you're in that space. But typically, if we have multiple parties fighting between and among themselves, that's a good way to really gunk up the works and make sure that we get enough leverage to negotiate a better deal.
How do you advise junior creditors to structure their interests in order to maximize protection in these distressed situations?
I am a fan of entering into intercreditor agreements. Let's just make sure we have clear lines of communication. If they don't want to play ball, then that's a whole other issue. But the if we can keep things out of court, let's do that. It makes more sense for everybody. And then as far as a junior creditor assessing the risk, we have to find other ways to get compensated for the risk. Do we start taking warrants? Do we get stock pledges? Are there other things that are able to be granted that are outside of the scope of the senior creditor that we can attach to? And those are the underwriting questions we're going to need to ask as we look to this. Or if, let's say, you're a junior creditor and we're looking at investment property, is there equity in the value of the home, and how quickly can we get out of that transaction? So you could play with the term. We could look at the cash flow. There's a variety of ways that we could underwrite the transaction to compensate for the risk.
What are the legal and strategic implications when junior creditors use nominee structures or other means to sort of mask their identity?
So it's challenging, right? Because you don't know who the party is, and so then if they're holding, for instance, in a nominee structure, if they're holding shares on behalf of some other party, the question is, well, who's that other party, and does that party actually have a perfected security interest? If it's legal, it's fine. I like to be clear about who owns what. It reduces allegations of fraud. It keeps people honest, and it knows, allows you to know who you're playing with. The counter argument to that is, let's say we have, let's say the nominee is a special purpose vehicle. Let's say that we've done a regulation CF crowdfunding round, and we're going to have 50 people on the cap table. Maybe that SPV makes sense to hold all of those shares, so that you don't overcrowd the cap table. It just kind of depends on what we're trying to do with the larger whole.
How can early intervention shape the trajectory of creditor disputes before a formal insolvency proceedings?
Well, if a lender can work out a deal, right, that's better for everybody, because once a bankruptcy court gets involved, the debtor may be in possession, but it's subject to the rights and interests of all the creditors. And you also have the Department of Justice kind of examining the conduct of the case. So if there's any questionable conduct by either the debtor or, frankly, the lenders, depending on who you're dealing with, you may not want to be in that scenario. The pressure that a lender is going to have in a workout situation is that, it depends on how they finance the transaction, right? Did they assign a stream of payments to somebody? Do they have investors that are expecting a return? So, we have to recognize that in a workout situation, all the parties have certain limitations. The question is, can we work around them or through them to come up with a mutually beneficial solution?
Sometimes just the threat of litigation drive favorable settlements or restructuring terms for your creditor clients. Because I mean, most companies want to stay out of the courtroom if possible.
It depends. It depends on the character of both parties. So most creditors don't want to be involved in litigation, and they would rather work something out because, again, paying an attorney just takes the juice out of the transaction that they're trying to achieve, right? Some debtors are deathly afraid of a lawsuit. Other debtors just are like, whatever, sue me if you can find
Come
me.
at me, bro.
Yeah, or just stick their fingers in their ears and close their eyes and pretend it's not happening, right? Yeah. So it depends on the character of the parties. So that's where I think taking a step back, if you're a lender and you're looking at lending money to a party, you really need to consider the character of your counterparty. You should, as a lender, get to know, especially if it's in a small, mid-sized business, really know the individual and the business, and get a sense of their history, why they're seeking financing, etc. If you've seen them refi out quickly or string along vendor suppliers, etc., you know that, or you should know that when things get tight, they'll likely do the same to you. So really pay attention, and to the businesses that are in the finance industry that are just motivated by hitting their quarterly goals or their yearly goals, there needs to be some sort of oversight on the sales team to make sure that we're not just financing hot air, and that we actually have a touch point from management on the debtor.
Finally, what are some key litigation risks and opportunities that you might consider when you're representing creditors in distressed transactions?
So a key litigation risk in a distressed transaction as you're representing a creditor typically comes to the regulatory risk associated with operating as a lender in California. California requires you to obtain a finance lender's license unless you meet certain exemptions. Many companies don't have their finance lender's license. And so what issues that opens you up to are potential allegations of unlawful and deceptive business practices because you haven't been registered or you're not providing the disclosures. Other issues that get opened up are issues related to usury, and that's where a debtor is most likely going to attack.
All right, interesting stuff. All right, well, thanks for joining us on Litigation and Capital. To connect with Steven or learn more about how Mirsky Corporate Advisors can support your business, visit MirskyCorporateAdvisors.com. And if you found this episode helpful, subscribe, leave a review, share it with your leadership team. We've got lots of great information coming your way in the future. Steven, always great having you here. Thanks so much for your time.
Thank you. Have a good one.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.